On August 1, Supreme Court of India delivered a landmark decision. It gave the power to state governments to subcategorize castes within the scheduled castes based on socio-economic backwardness. So far, 15% reservation for scheduled castes in government jobs and education has been implemented without any micro-differentiation. With this 6-1 decision, the apex court acknowledged that certain communities within the scheduled castes had cornered reservation benefits, and the states had the right to correct this. It is Tuesday, the 6th of August. From the Economic Times, I'm your host Nidhi Sharma, and you're listening to the Morning Brief. So last week, the Supreme Court addressed a politically sensitive issue of quota within quota. At present, the Indian Constitution prescribes 15% quota for SCs, 7.5% for STs, and 27% for other backward classes or OBCs in educational institutions and government jobs. There is no prescription as to which community within the SCs, STs, or OBCs gets how much reservation. This means there is no categorization of communities belonging to SCs, STs, or OBCs. Over the years, certain communities have benefited more from reservation compared to others. This means that they may not be numerous, but reservation benefits have been utilized better by them. This has triggered specific demand for quota within quota. This means that, say, 15% quota for SCs should be further divided to give specific communities more reservation or representation than certain other communities. Now, from Mandal Commission agitation in the 1990s to what we have seen more recently in Bangladesh, we know the issue of reservation can inflame extreme sentiments. Because it's not just about social justice, but also about political heft. So let's trace the demand for subcategorization of SCs, or what we are calling quota within quota. In 1975, Punjab government issued a notification dividing its SC reservation into two categories. First category comprising of Balmiki and Mazhabi Sikhs, and second was the remaining SC communities. A similar move was initiated by Andhra Pradesh government under Chandrababu Naidu in 1997, when through a government order, it tried to give preference to Madiga community over Malas. Now, Malas are a dominant SC caste. I have with me Mr. Kadyam Srihari, who was the Social Welfare Minister in Naidu cabinet when this move was initiated. Mr. Srihari, what was the reason behind subcategorization of SCs?
In combined Andhra Pradesh, the agitation for subcategorization of scheduled caste reservations started in the year 1994. The main demand was the 15% reservations which were earmarked for scheduled castes are not equally disputed among scheduled castes. Only certain castes are getting benefit. So agitation started in the year 1994 saying that the reservations should be equally disputed on pro rata basis, that is on the basis of the population of the subcastes among the scheduled castes. And this demand got the acceptance of all the political parties. This was challenged by Mala Mahanadu, which is opposing the subcategorization of scheduled castes. The main claim of the Madigas and Madiga affiliated castes is that Malas are getting a major share of the reservations, Madigas are not getting. So After the government issued a GO and started implementing subcategorization of scheduled caste reservations, Supreme Court struck down the GO of subcategorization, saying that state has no power. Only Parliament can do subcategorization through an amendment to the Constitution.
Sir, was there a survey conducted by the Commission or the government to quantify the communities under SC category?
Justice Ramchandra Rao Commission collected all the information from educational institutions and from government offices. How scheduled castes are being represented, what is the ratio, how Malas got admissions in institutions and employment, and how Madigas are getting their share. So there was a very clear-cut difference, margin between Malas and Madigas. Actually, among the scheduled castes, in combined Andhra Pradesh, the Madigas population is more than Malas. And even in Telangana, the Madigas are more than 70%. Malas are just 30%. In combined Andhra Pradesh also, Madigas are around 65%. Madigas are 35%. But in reverse, in educational institutions and in employment, Malas used to get more than 60 to 70% share, where Madigas used to get only 25 to 30%. That was the result by which this agitation took place.
Sir, right now, what do you think is the way forward, both in Telangana and Andhra Pradesh?
I sincerely think now there is a necessity for subcategorization of scheduled castes. Even Dr. B.R. Ambedkar also said in the Constitution, the fruits of Constitution should be equally distributed among the people. So, keeping that spirit in mind, subcategorization is very, very essential, not only in Telangana, wherever it is happening. This demand is there in Karnataka, this demand is there in Andhra Pradesh, this demand is there in Telangana, this demand is there in Punjab. In many states, this demand is there. The people who are enjoying the fruits of Constitution, the people who are getting share more than their population, are opposing this.
So, as Mr. Srihari explained, subcategorization of SCs remained in place till 2004 when in E.V. Chennaiya case, a 5-judge constitution bench struck down the Andhra Pradesh Scheduled Castes Rationalization of Reservations Act 2000. Then United Andhra Pradesh Assembly passed a resolution and asked then Congress-led UPA government to intervene. The centre tried to find a way around the issue and a national commission under Justice Usha Mehra was constituted. The commission submitted its report in May 2008 recommending amendment of Article 341 of the Constitution to provide for subcategorization of SCs. In 2011, the Ministry of Social Justice and Empowerment began the process of seeking comments from the states. 14 states, including BJP-ruled Madhya Pradesh, Gujarat, Himachal Pradesh and Uttarakhand, have opposed the centre's proposal to subcategorize SCs and only 7 have supported the move. I am joined by former Secretary of Social Justice and Empowerment Ministry, Mr. R. Subramaniam, who will help us understand what is the way forward. How do you see this order and what exactly is the way forward?
Primarily, the Supreme Court judgment has vindicated the stand taken by some of the states that there is a need for subcategorization in view of the unequal access to the benefits of reservation within the SC communities. As we have seen, this particular demand has come only from few states. So the path is going to be somewhat critical and also complicated because the states which want to do the subcategorization would need to collect data. This data is not the data about the communities. It is the data about the access of the benefits by various SC communities in various public employment and also in educational institutions as a part of the reservation. So I think this data collection is going to be complex and it will not be easy. And probably it may require some sort of a house to house enumeration also. We have seen in the past that Supreme Courts have not allowed, wishy-washy sort of reports in the data collection. So this is a complex process. So I suppose those who want to do it will have to really embark on it sincerely.
Sir, earlier there have been attempts at collecting data, like when Andhra Pradesh did it in the 1990s. There was a representative kind of a data which the commission also took. Is that not an option, sir?
So these are two separate things. Suppose if you want to join a community or remove a community from the existing list, then it is sufficient if you do a socioeconomic study of that community. But when we are trying to subcategorize, and based on that subcategorization, you are actually giving a preferential or non-preferential treatment to certain community, I suppose the data would need to be a lot more detailed and more probably household wise. So it needs to be examined further. But it appears that a simple socioeconomic study of a community will not be sufficient to say how much of this reservation should be allocated to that particular community.
Sir, is this a good way to ensure reservation benefits reach the underprivileged among the SCs?
Punjab sought to make this classification, and that is what has actually led to this Supreme Court case in state of Punjab versus Devinder Singh case. So nowhere has a subcategorization of the SCs been done so far. So this is going to be a fresh attempt. And I'm certain that those of the communities in the SCs who are neglected, who did not get access to benefits, will definitely benefit by this. But having said that, I don't think reservation is the best of the affirmative actions. See, this is the last resort. Reservation is the last resort. Affirmative action has got several steps, like, for example, ensuring that they get all entitlements, ensuring that all of them get access to good education, and ensuring that they all get access to good skills, and then providing funding for their education or skill development. These are all affirmative actions which must precede trying to do any reservation related work. This is, I strongly feel in that. And many times we focus so much on reservation, we actually don't talk about whether that affirmative action in terms of provision of education or, providing affordable education, quality educational skills, whether it is actually happening, and if it is happening, is it happening effectively or not? That is something which we actually forget. Insist that, any state which is looking at subcategorization must really start from the beginning in providing education, health, skills, and things like that.
Sir, when this is implemented, you said it will still need to go to Parliament. So every state that seeks to do it will have to do it, and it cannot be that the center will need to do it, or the center can take a view and have a blanket kind of the way it is being followed right now. It can't be done like that, sir.
See, presidential order specifies the list of scheduled communities, scheduled castes. We are aware of 340, Article 341. Any change in Article 341 can only be done by Parliament. It cannot be done by state assemblies. So on that point, there is absolute clarity, and I don't think Supreme Court has made any changes in that. It's not intended to also. So any state which wants to make a change in their scheduled caste composition for their particular state, either by adding a community or giving a preferential treatment to one of the communities which are already in the list, that needs an amendment of the presidential order to the extent of that particular state. And that can be done only through a legislation in Parliament. So the state will have to first do a study. They have to come to a conclusion based on the data that yes, there has to be subcategorization, and then pass a resolution in the assembly, and that will have to go to president. And there, after getting the presidential assent, so the concerned minister in the central government will have to move a bill in Parliament.
Sir, there would be a need to define the creamy layer in SCs also then, the way it is done in OBCs.
So basically, the court has extended creamy layer to the scheduled caste reservation. So to that extent, this is going to be a very contentious issue primarily because how do you define a creamy layer here? This is not the same definition as the OBC creamy layer, which itself is undergoing some amount of examination. Yeah, but this has to be completely different. And what happens in the case of scheduled castes is that it is not an economic condition-based reservation. This is a social reservation. So therefore, I don't know how do you define this creamy layer. It obviously cannot be defined in economic terms. So what are the terms that the government should define? This creamy layer is something which we have to wait and watch. All the scheduled caste communities will really agitate if you apply economic criteria for excluding scheduled caste, because even if they're economically better, they're still socially discriminated. And this we are seeing in the real life. You may be an IAS officer, but it's very difficult to have an intermarriage with the non-SC persons. And we are seeing it across the country. So therefore, I feel that these reservations have come out of centuries of perpetration of atrocities on these communities. It will be very fallacious to apply economic criteria to these reservations in the name of the creamy layer. The creamy layer can be defined in social terms. Probably it can still be considered. But as of now, it has to be very, very different from what we do for OBCs.
But the biggest aspect of this remains the politics. In 1975, when Gyani Zail Singh government had initiated this move, he had tried to wean away Mazhabi Sikhs from Akali Dal. In Andhra Pradesh, Chandrababu Naidu supported the demand for quota within quota as Madigas were resisting the influence of Malas, who had been a support base of Congress. In Bihar, Nitish Kumar came up with his own concept of Mahadalit to fragment this monolithic constituency of SCs and cull out a dedicated voter base. In Tamil Nadu, DMK has courted the Arun Tatyas through a similar move. But the tricky question here is, how do political parties engage with the caste which may be expected to forego its supremacy over the rest? In this case, how will they quote Malas in Andhra Pradesh and Telangana, Chamars in Punjab, and Paswans in Bihar? This is clearly reflected in BSP chief Mayawati's opposition to the judgment. Parties like BSP that have traditionally based their politics on consolidation of the Dalit community would not want fragmentation of this vote base through subcategorization, especially since it pits one subcaste against other subcaste and threatens to dent the pan-Dalit consolidation they have achieved over decades. I hope I have been able to deconstruct this issue for you. Hope you enjoyed listening to this episode of The Morning Brief. I'm Nidhi Sharma, signing off. This episode was brought to you by sound designer Rajas Nayak and producer Vinay Joshi. Executive producers Anirban Chaudhary and Orijit Barman. Thank you for listening, and if you like this episode, do spread the word around. All new episodes of the Morning Brief podcast drop every Tuesday, Thursday, and Friday. It streams on Amazon Prime Music, JioSaavn, Spotify, Apple, and Google Podcasts. And of course, ET's own audio platform, ET Play. Have a great week ahead.